And because they have more individual needs or welfare needs, which the welfare approach says comes first really, or hand in hand with justice, you may have a situation where you've got a youngster has committed a crime, and then a youngster's committed the same crime, maybe in a different area, but they're being dealt with differently. Now, this is always going to be a criticism and a problem that we can see within this system, because the justice system, quite rightly, some might say, it's there to punish regardless of those welfare issues. And is it really fair and a just system where you've got youngsters who are committing the same offence but being dealt with differently? And there's always going to be this conflict between the two approaches. Going back to the question about welfare, welfare is nothing new. In practice, within the youth justice system, there has always been an element of welfare there. And the modern juvenile justice system emerged roughly around the period as adolescence and delinquency were discovered. And many of the social reformers in the 19th century who campaigned to protect children from danger and exploitation demanded that they should be removed from that adult prison system, and instead wanted them to be placed in privately managed, state-funded institutions. So this idea of welfare, as we can see, is not anything new really. Dates back to the 19th century. And here we saw the Youthful Offenders Act of 1854, mainly real first piece of legislation, and provide the basis for the reform within the youth justice system. And although the institutions which were formed under this act were part of the educational system rather than the penal system, they housed children aged 7 to 14 who had been convicted of vagrancy. So the juvenile courts then were formed and formalised under the Children Act of 1908. And this stopped under 14s from going to prison and restricted imprisonment also for those youths who were 14 to 15 years of age. So as you can see, again, nothing new really. It's been around, that welfare issue regards to youngsters, has been around for a long time. Welfare concerns were given then further thought under the Children and Young Persons Act of 1933, and this prohibited capital punishment for those under 18, again thinking of welfare issues. So also at the same time it recognised things such as industrial schools and bringing about the creation of these approved schools where they would provide education for juvenile offenders. The 1940s then saw further restrictions on the use of imprisonment of juveniles, and this then marked the beginning of a trend, or what we saw as a trend, of restricting the use of custody for juvenile offenders. So by the end of the 1950s, we saw what was called the Ingleby Commission, who tried to focus on a conflict between judicial and welfare functions of the juvenile court. So as I've said, there's always been that concern with regards to welfare. We've also seen that conflict between welfare and justice. So again, that's nothing new really. So proposals then that came from that Ingleby Commission was to raise the criminal liability and responsibility of juveniles to 14. This didn't become law. However, the Children and Young Persons Act in 1963 did successfully raise the criminal responsibility to 10, which is what we also have now. So any young person who is aged 10 and above can be held liable for their offences. What followed then in 1969, at the end of that decade, we saw a highly welfare-orientated piece of legislation come about, the Children and Young Persons Act 1969. And this piece of legislation sought to make care more important than criminal proceedings, with that intention of the juvenile court becoming a welfare agency, and as stated by Rutter and Giller in 1983, the agency of last resort really. Again, welfare coming first, criminal proceedings, and the court, the juvenile court, being that last resort. However, politics of youth crime were beginning to change, and specifically when we had general election in 1970, it put a stop really to any possibility of that 1969 Act being fully implemented. So the consequence of that, basically seeing juvenile courts continue as they were functioning before. So even though we had this really important piece of legislation, didn't do much in terms of creating that welfare. Moving on from the 70s, it was during the 80s that we had this sense of prison was ineffective as well as being expensive, and that idea, that sense, started to develop in relation to juveniles in particular. So in 1988, the Home Office published their Green Paper, which was entitled Punishment, Custody and Community, stating that most young offenders grow out of crime as they get older and more responsible. They need help and encouragement, and even short periods of custody are likely to confirm them as criminals. And what you can see here is that labelling starting to come about. Youngsters, if they are sent to prison, locked up, labelled as a criminal, they start to act like a criminal, hence the word labelling. So what's the consequence of this labelling issue then? Well, what becomes a core objective for juvenile teams and social workers was to move away from that charging penalty and encourage the cautioning rather than the charging. So rather than custodial sentences, and this is known as diversion. So that's a little bit of history, and basically stating the fact that welfare is nothing new, and the difference between welfare and justice. And as I said, you're always going to have this conflict between the two. So we had that back in the 19th century and leading up to 1970s, 1980s. So where did it all change? This shift in youth justice with regards to policies and so on started in the early 1990s. Two events really that kicked this all off. The urban disturbances in 1991 and the rise in moral panic concerning these so-called persistent young offenders. And in 1991, a number of small towns and cities, part of Cardiff, Ely in particular, experienced these outbreaks of disorder and issues surrounding joyriding. Very, very high rates of joyriding back in the 90s, and not something that we really see these days. They've moved on to other things such as county lines, major drug issues, particularly in Swansea areas, but going off a little bit. The media back in the 90s with regards to this focused on these stories, fueling the fire really, fueling this moral panic amongst the public by printing stories about these youngsters and instilling this public concern really. So what happened? We had the first issue of the urban disturbances, but what we saw specifically in 1993, which sparked public outcry again, was the case of Jamie Bulger. Horrendous case where two young boys, 10 at the time, were seen by CCTV leading away 2-year-old Jamie Bulger from a shopping centre, took him away and just committed horrific assaults on the 2-year-old boy and murdered him and left him on a railway. Now that, as I said, caused massive public outcry, and Birkeland in 1997 described this case as really a focusing event, a dramatic and sudden event really that we're seeing with youngsters where, okay, somebody needs to now take heed and something needs to be done. As a consequence of this, we saw specifically Michael Howard at the time respond by announcing a package of measures with the central position really of custody being part of a range of sanctions with juvenile offenders, and the whole point of this was deterrence, trying to stop and make an example really of these youngsters. More famously, he announced that previous approaches which did involve attempts to limit the prison numbers were now going to be abandoned. Obviously the new measures, knock-on effect consequence is that prison numbers are going to increase, and an increase did happen, and the stats from that time show a 79% increase in custodial sentences, specifically given to 15 to 17-year-olds between 1992 and 1998. And the number of young people who are serving custodial sentences more than doubled between this period. So doing what he wanted it to do, I suppose, but is that the answer, or was that the answer? Up until 1998, a child under 14 could only be convicted of a crime if the prosecution could prove that they knew what they were doing was wrong. This was a principle that was abolished with the Crime and Disorder Act of 1998, consequently after the Thompson and Venables case, as described just now with Jamie Bulger. The Crime and Disorder Act of 1998 also led to the creation of youth offending teams in England and Wales, and also led to a new approach based on risk factors. So in other words, a sentence being determined by the risk of what a young person may do in the future. So looking at these risk factors, they were looking at risks such as the community that the young person is living in and the quality of the parental support they're receiving at home. So welfare issues are taken into account, but only insofar as they might increase chances of offending again. Criticisms, yes, it reintroduces that welfare issue, that welfare model, but without requiring that welfare issues are raised in the first place, and in the risk assessment that they're actually addressed, so they consider the risk factors. Going back slightly to the welfare issue, however, not necessarily addressing those risk factors, which is the core of the problem really in most circumstances, and something that does need to be addressed. So in order to deal with that particular criticism, something called asset plus assessment was introduced to try and counteract that criticism really. So let's look back at the question in hand. Is a return to welfare the appropriate direction for future youth justice practice? Let's think about the Bulger case and the two sisters. They were aged 12 and 13 who kidnapped a child to abuse. Equally disturbing as the Bulger case. Two girls tried to take a child from Primark. What we need to do is ask, well, what drives a young person to do such a thing? This is unfortunately that dilemma that is faced by policymakers, criminologists and us, the public, when we are faced with a child who commits such a horrific criminal offence. So do we focus on what drove them by addressing their personal circumstances, what drove them to do that, or focus purely on the crime itself and punish the offender accordingly? Constant dilemma really, and still going back to that battle of welfare versus justice. So welfarism has never been universally accepted as the most favourable means of responding to youth crime, and it seems we could have an outdated view really of welfare and what happens when we punish too far. And the two fundamental problems here One being the resurrection of welfare, and two